and welcome to everyone to the first in a weekly series of webinars sponsored by the International Land Conservation Network and the European Land Conservation Network with other partners across the globe. Some of you may have tuned in last week to the plenary session on Earth Day, which included a special message from His Royal Highness Prince Charles and presentations from distinguished leaders in Catalonia, Spain, and in California in the US. It was a really inspiring start to this webinar series, and we are excited to bring to you an exceptional panel today to discuss common law tools and strategies in common law, common law jurisdictions. So now it is my pleasure to introduce Victoria Marles, who has been the CEO of Trust for Nature in Australia since 2009. Vic is a lawyer by training and a key conservation leader in Australia. She's also served on the ILCN steering committee since our founding about 5 years ago. And Vic has also played a key role in the development of the Australian Land Conservation Alliance, ALCA, over the last 6 years. So Vic is the moderator for our webinar today, and I will turn the program over to her to introduce further our topic and our panelists. Over to you, Vic.
Thank you very much, Laura. It's very exciting to be here today. And as I understand it, we've got people from almost 32 countries around the world joining us at this webinar, which is, of course, very exciting. So, conservation tools and strategies in common law jurisdictions, that's what we're going to be hearing about today. And what we know is that organisations and conservation practitioners use a range of agreement types to protect private land rather than simply owning the land. And today we're going to be focusing on countries which have been using conservation agreements for many years and so have a body of practice behind them. We'll be looking at Australia, New Zealand and the US. And in addition to hearing about the core agreements and how they work in these countries, we're going to be delving into some of the challenges that emerge over time. For example, the enforceability of agreements in the face of climate change and the need to balance the permanence of agreements with the flexibility that you have to have when you have agreements in place for a very long time to adapt to changing circumstances. We are going to get an overview of the growth, the role and the importance of private land conservation and protection in Australia and New Zealand. And we're also going to be hearing about how strategic uses of these agreements are evolving in response to the big changes which face us, how they address serious biodiversity loss and increasing climate change impacts. And I think the presentations are going to give us a glimpse of the varied current and potential uses of conservation agreements, in particular in the context of productive and working landscapes. Now, while all of the speakers come from common law countries, the nature of financial incentives available to landholders differs considerably between those countries. And so we're going to hear about some of the approaches to incentivising permanent protection in different jurisdictions. So I would now like to introduce our speakers. First of all, we're going to hear from James Fitzsimons, who's the Director of Conservation for the Australia program of the Nature Conservancy. James oversees the organisation's conservation planning, science and policy functions in Australia. And this includes major conservation programs across Australia, for example, in the vast tropical savannas of Northern Australia and the diverse central deserts. James is one of the most knowledgeable people in Australia and beyond on the current status and contribution to biodiversity of privately protected areas. Then we're going to be hearing from Mike. Mike Jebson is Senior Partner at Southern FALCON Consulting Limited, and this is a New Zealand-based environmental consultancy that provides expert consulting, policy and executive management services to the full range of organisations, from rural landowners right through to commercial bodies, NGOs and governments, regarding conservation and environmental issues in New Zealand and internationally. Up until 2019, Mike was the Chief Executive of the QE2, Queen Elizabeth II National Trust, and this is New Zealand's leading private land conservation organisation. And during the mid-2000s, he was lead climate change negotiator for the New Zealand government for agricultural and forestry. And last, but certainly not least, we're going to be hearing from Jessica Owley. Jessica specialises in environment and property law at the Miami University, USA. She's a leading expert on private land conservation and conservation easements, and her interdisciplinary work explores ways to mitigate and adapt to climate change, as well as furthering other environmental goals in the context of drastic change. Prior to becoming a highly credentialed academic, Jessica practiced in the area of land use and environmental law in San Francisco. She's one of the founding members and current president of the Environmental Law Collaborative, and she's a member of the IUCN's World Commission on Environmental Law and the World Commission of Protected Areas. So what a great panel. And now I would like us to begin, and I'm going to hand over to James to begin to tell us a bit about what's happening in Australia. Over to you, James.
Thank you, Vic, and hi, everybody. As Vic mentioned, this talk today is going to be about what are some of the emerging trends in Australia for private land conservation, and particularly in largely agricultural landscapes and landscapes that have Indigenous cultural value. So first we'll step back and have a look at a bit of the history. And if we go to the next slide, we'll see that Australia's reserve system has grown quite dramatically. So this is back in 1997. The combination of the state and other agencies' nature conservation reserves, it covered about 7% of the continent back in the mid-90s. And if we go to what it looks like more recently in the next slide, we can see we've taken that to about 19% of the continent in a fairly short amount of time. The next slide will show us how we've changed the system. We've gone from largely a public, national parks, public nature reserves estate to an estate now that's made up half of Indigenous land and private land as well. So a big change in the land tenure, land use type in our reserve system as we've grown it over time. If we go to the next slide though, we'll see that while we've done really well in representation of some of our bioregions, our ecoregions have been reserved very well. Others, predominantly in the agricultural landscape and those productive landscapes, are still fairly underrepresented. And they're the sort of the big focus that we need to look at now. These are the highly productive, high soil quality areas that we need to start thinking about for new mechanisms to get conservation to the system. If we go to the next slide, we'll see that Australia has really expanded its private protected area estate. We've got about 5,000 odd properties. That was back in 2013. We're probably about 6,500 now, covering up to 22 million acres, or about 8.9 million hectares. So we're probably the second largest in terms of number globally. We're by far the largest in terms of area, in terms of privately protected areas. And these fall under two main categories. One is conservation covenants. And for those in the US, they're quite like conservation easements, but they're much more focused on mostly natural areas. So very little farmlands being protected under conservation covenants. It's mostly about native vegetation. The other major category is around private land trust reserves. So those reserves owned by organisations like the Nature Conservancy in Australia. Other large land trusts include Bush Heritage Australia and Australian Wildlife Conservancy. I'm going to hand back now to Vic to talk about the oldest conservation covenanting program in the country, and that's Trust for Nature.
Thanks, James. So Trust for Nature has been operating for nearly 50 years. And we have protected we've got nearly 1,500 covenants in the state of Victoria. In Australia, in order to be able to put conservation covenants on, we need an Act of Parliament, so we get our power from a statute. I'm not going to go into how it all works because Mike Jepson is going to be talking about the mechanics of conservation covenants. Both the QE2 Trust and Trust for Nature were established at very similar times and obviously had reference to each other in how they were set up, so there are great similarities. I think that James has indicated one of the challenges for us in Australia, which is that conservation covenants have typically protected high quality, remnant native bush and vegetation, and we know that we need to move into the area of protecting productive and working landscapes. So one of the things that Trust for Nature is working on with others is how we adapt the Conservation Covenant to be able to do that. And so we're doing some work currently around Victoria with some farmers to trial our adapting the Conservation Covenant to farm covenants. One of the things that we want to do is we want to use this as a tool for protecting conservation assets on productive land, and also for recognising and embedding sustainable land management practices. So not just the asset, but the practices as well. And we're very excited about this piece of work. The other thing that we're going to be doing is looking at the covenant and seeing whether the covenant can be used to protect cultural heritage. We have been having conversations with, in Victoria, the Federation of Traditional Owners, the First Peoples of the land, and having a look at, in circumstances where the land is owned privately, whether it's possible to use the covenant as it is to explicitly recognise cultural heritage on land and impose obligations and restrictions on how that land is being managed to protect that cultural heritage. We are in conversation with private landowners plus land trusts and, as I say, the Federation of Traditional Owners themselves to talk about how that can happen. So that's a very exciting development for us in the use of covenants in Australia. Back to you, James.
Thanks, Vic. So I'm going to talk about two large properties that the Nature Conservancy has been involved with just across the border in New South Wales to the north, where we do have very large landscapes coming from former agricultural use with high conservation values, but also high cultural values. The first one of these is a property called Guyeni Nimikaira. And if we go to the next slide, we'll see this property is embedded in this landscape, this now conservation landscape adjoining a very large national park that was purchased about 25 years ago, Yanga National Park, and a property that was purchased subsequent to Guyeni Nimikaira, the Great Kumbung. This whole landscape now equates to about 190,000 hectares, or about 500,000 acres. If we go to the next slide, this is a very interesting property deal. Basically, it's 88,000 hectares of freehold floodplain. The whole area is a wetland of national and if not international significance. It was 19 different irrigated farming properties that were purchased by the New South Wales government. And with critical funds from the Australian government. For the Australian government, it had water rights, which were really important to, I guess, resolve some of the issues about the lack of water going to the environment of the Murray-Darling Basin. And this was an opportunity to buy back large water rights and a large area of properties to see managed differently, and for water to be used more equitably for the environment in this part of the world. It was a very large purchase price in Australia of $180 million. Interestingly, what the government did though is they didn't just reserve it as a national park, which typically happens when land is purchased. They put it out for tender for consortia to bid based on management around environmental, Indigenous cultural values, and allowing some commercial enterprises where that was sympathetic to those other values. If we go to the next slide, we'll see this for us, the Nature Conservancy was a lead proponent in putting it up, and we were lucky enough with our partners, the Narri Tribal Council, the local Indigenous group, the Murray-Darling Wetlands Working Group, an environmental water deliverer in the landscape, and the University of New South Wales. We collectively put up a bid, and we were successful in being awarded this property on a long-term lease. And just critically, more recently, we've been able to hand this title back in freehold to the traditional owners, which is a very historic event in these agricultural landscapes, because very little land is owned by traditional owners in these highly productive landscapes. So the vision is to, I guess, build this self-sustaining model for the property whereby environmental and cultural assets are at the forefront. The Narri Tribal Council and traditional owners are up front, they're managing it, and really it's our organisations behind the scenes helping as part of a network of partnerships. If we go to the next slide, you'll see this is a really diverse area with really different wetlands, big floodplain wetlands, the largest lignum wetland in whole of Australia, big areas of red gum floodplain forests and others, really important for a whole range of water birds. Next slide, please. And Interestingly, in terms of protection, this is probably, in terms of protection overlays, probably the most highly protected one, area in the country in terms of private land. It's quite amazing. It's got a whole range of existing soil conservation easements on there for water flows. There's going to be a new land and water management plan that now sits on the title with a covenant. New easements for new flows are going to be in place. A healthy country plan whereby planning is dictated and really driven by the traditional owners has been done as well. We've got future aspirations for a stronger conservation covenant on title, which in New South Wales enables in perpetuity stewardship payments, which is a really important new model in Australia. We're looking at Indigenous protected areas agreements between the traditional owners and the Australian government, and Ramsar listing, which conveys even further protection under our national environment legislation. On to the next slide, please. It's a really interesting landscape in Australia. Our wetlands are very much a boom and bust system, certainly down in the south in the Murray-Darling Basin. This is a big, vast landscape, formerly irrigated, and at times from the air, it looks pretty bare and barren. You can see the little drainage lines running through. But if we go to the next slide, you'll see this area really comes to life when that water is put down the system. It really transforms the system into quite an amazing biodiversity-rich landscape. And if we go to the next slide, one of the key elements in this landscape is pushing water through the existing irrigation channels, using existing infrastructure to better get an outcome on the landscape, not knocking all of that over, using that for the purpose of getting ecological processes and hydrological connectivity through the landscape. Next slide, please. And you'll see that how that's been done is basically utilising existing infrastructure like weirs and channels and regulators and the like to do so. If we go to the next slide, this lease triggered interest from an adjoining landowner to the north who owns this property called the Great Cumbung Swamp. If we go to the next slide, you'll see this area is very nicely complementing up to the north there in the pink, going in Imikara down to the south and Yanga National Park. It's about 33,000 hectares or about 84,000 acres, and it was just purchased just early last year in 2019. If we go to the next slide, this is quite a property with a different range of partners, which I'll talk about shortly. It's the largest reed swamp in the whole of the Murray-Darling Basin. It's the confluence of two rivers, which at the moment aren't quite meeting due to changed water flows. And one of our big ambitions is to link those two up. Again, another globally important site for water birds. It also has strong Indigenous cultural values. If we go to the next slide, this property was a different sort of deal. This was a 50-50 joint venture partnership between the Nature Conservancy and an organisation, Tiverton Rothwell, who's a sustainable agricultural company and conservation organisation as well at the same time. And so this property was a different sort of deal. We paid $55 million Australian for that, which again on the open market, it's a large amount to buy for private land for conservation. We have joint objectives. Conservation, of course, is one of the primary ones, but I guess subsidising that with sustainable production is really important as well. So that might be grazing, that might be firewood in the short term, that might be biodiversity stewardship payments, which we're hoping to seek in the very near future. We do want to link these two rivers up and improve connectivity between the two, and we do want to get a conservation covenant and potential Ramsar listing in the future. On to the next slide, please. So this was, I guess, a different deal in terms of the way we financed it too. So we had that core of philanthropy, and these figures are in Australian $1 million each, so $7 million. We were able to get a low interest loan from our local bank here in Australia. We took out a $15 million loan from our land preservation, from impact investing. So Tiverton Rothwell were able to secure investments from their investors into this property, acknowledging they will get a return out of that. We took another 15 from our land preservation fund, our internal fund, and we were able to sell off the water rights on the property. We didn't need them for agricultural purposes. We sold them back to the Australian government for use as environmental water. So this is kind of the, I guess, the capital stack for how we got to that purchase price. If we go to the next slide, please. Some of the challenges from both properties are or some of the key lessons I should say, is that sustainable development, at least in part, is going to be important for financing these very large properties in these landscapes. Consultation can be challenging depending on I guess, the restrictions in both the timeline for getting a deal like this done on both properties, but also under, I guess, some of the confidentiality clauses you might be under as well, which was the case with the Gaini-Mikaira process. There are always compromises in these situations. I mean, ideally, you might want to have the whole lot under conservation with no commercial production, but realistically, you have to have some there to fund very large and expensive purchases. They are large and time consuming. If we go to the next slide, some of the key lessons and future directions. There's going to be a much bigger need for these larger landscape scale initiatives and bolder thinking from both the public and private sector to do deals like this. They're going to be more complex with high capitals and different partners from different sectors. We're going to need to incorporate that productive use to finance the deals, but also for social license, to be able to show that there are jobs being maintained in these local regional landscapes. The diversity of income streams on the property is going to be really important. These deals are really important for four main reasons. One is to meet our national and international conservation goals under the Convention on Biological Diversity. It's to show that conservation and production can coexist in the landscape, to show that new and diverse models can work, but critically to be competitive with other well-financed agricultural production companies. If we can't find diverse partners to raise that sort of money, we will be outbid every time by larger agricultural companies in these landscapes. And the next slide, I think, is the last, and I will leave that there.
Thank you very much, James. That was terrific. Now we might take a couple of questions before we move on to Mike. Just to kick things off, James, I was wondering if you could tell us a bit more about, I mean, this is obviously a very big, complicated project, and in addition to protecting assets, it's obviously embedding conservation management practices. How is TNC going to go about monitoring and overseeing those practices over time?
Thanks, Vic. Yeah, so look, in the Gaini-Mikaira example, it's quite a regulated process. Again, the New South Wales government, when they purchased these properties, had in mind the way they wanted to see that managed in the long term. They didn't have an idea about the consortia that were going to bid. So what they had done was set out what they thought in a land and water management plan needed to happen regardless of who was owning or managing this property. And so there was some quite specific arrangements around monitoring what had to be monitored and by when. Fair to say, once we won the tender, there was a fair bit of negotiation around what that looked like. And so for us, having a partner like the University of New South Wales, having Wetlands Working Group, having people on the ground through the Narrabri Tribal Council have enabled us to, I guess, have that broad suite of different skills and monitoring protocols to allow us to do that. Now, there are obviously regular processes for reporting back to government in this arrangement as well, which is really important. So it's overseen by a management plan, a comprehensive management plan that actually sits on title. It's enhanced by a healthy country plan, and monitoring is a regular occurrence from there.
Great, thanks, James. I'll see if there's any more questions out there.
I can, it's Laura, just a quick one, well, maybe a quick one, James. I just think these projects are amazing, but you have emphasized how complicated and expensive they are. So how realistic is it, do you think, to be able to meet the need to accelerate these kinds of approaches? Particularly, I'm struck by the role of the government of New South Wales and the complexity of that relationship.
Yeah, it's a great question, Laura, and I think, you know, that the complexity will make everyone think carefully about how we do this again. But I do think you're right. The critical role of government in there to enable that original purchase to happen, to be thinking down that line is really important. I do think there are other policy levers we can draw on here. This was a high-profile property that both sides of politics really liked at both the state and federal level, and I do think more of these situations are going to occur in future, I guess, as we see climate change, as we see systems becoming increasingly marginal for agriculture. There's going to be different ways of thinking about landscapes whereby we still want to have people in the landscape and production there. it might not be at the same intensity we've had in the past. So we're going to have to look at solutions anyway, I think by default. And this example is going to show how we can do it, how it was complex, but how we might make it simpler in the future.
Thanks, James. I'm going to take one more question because we've got some questions coming in now from the participants in the webinar. So just one final one at this point. Could you provide some info on how biodiversity stewardship payments work?
Sure. So I think it's only in New South Wales across Australia is the only state offering these arrangements on title. So basically an assessment will be done of your property, and an assessment will be based on vegetation quality, how high priority that vegetation is, what you're planning to do. And basically it could be as part of a tender whereby you're bidding in, or it could be a set price. And basically that allows a yearly or annual payment to be made based on the value of that property, as well as the size of the property as well. There's a calculation made in a set formula to enable that to happen. So if you sign up for a conservation covenant, typically that's the most likely to enable you to get the stewardship payment. There is money set aside in a much larger trust fund to enable that in perpetuity payment to happen.
Yeah, great. As someone who lives in Australia, I can echo what James is saying. It's a very exciting development that's happening with stewardship payments in New South Wales. So what we're going to do now is move on to hear about what's happening in New Zealand, Mike. Over to Mike to tell us about all of that.
Ngā mihi nui, Vic and Laura and James. Yeah, no, I'm going to talk about the legal situation in terms of covenants in New Zealand. As Vic mentioned, our covenants, legally, the framework is quite similar to Australia, although there's a couple of key differences. Next slide. So what I'm going to talk about is the context of the QE2 National Trust covenants. It's a great privately protected area success story. I'm going to talk about how the QE2 National Trust went about balancing protection with flexibility. But I'm also going to talk about some of those challenges that comes with success. This is in relation to monitoring, change of ownership, and compliance and enforcement. And with the last couple of minutes, I'm just going to touch on some early thinking about some next generation covenants. Next slide. Well, all I can say is the QE2 National Trust, it's been a fantastic success story. Over the last 40 years, the QE2 National Trust has averaged about 108 new covenants every year. So that's over 2 new agreements every week to protect land all over New Zealand. The main focus of our covenants is biodiversity and landscape protection, though also like Australia, we do have a number of covenants that have cultural and amenity values as well. Next slide. Okay. One of the outcomes of this is it's a great success story. So QE2, it itself has almost 5,000 covenants protecting about 187,000 hectares. But we have our government covenanting agencies in the Department of Conservation and Ngā Whenua Rāhui, and collectively those two organisations have protected about another 1,200 covenants. So in total, New Zealand has 6,200 covenants that would meet or exceed IUCN best practice protected area guidelines. Now that's fabulous when you think about New Zealand already has a very large area of public land that's protected, about 30% of New Zealand. We've also got another 2% which is protected on private land through our covenanting mechanism. Next slide. Now, in the case of QE2, particularly, I'm not going to talk about the DOC covenants. I'm going to focus on QE2 because that's what I know best. Our covenants come in all shapes and sizes. So while they average about 40 hectares, that's about 90 acres for our American colleagues, the medium size of our covenants is less than 6 hectares. Now, the disparity between the average and medium size is that we've got a relatively small number of huge covenants and lots of covenants less than 100 hectares and some less than 1 hectare. We've also got a very interesting spread of ownership. So about a third of our covenants are protecting natural areas on family and corporate farms. Now, usually that's only 4 or 5% of the farm, although we do have a small number of covenants that are whole of farm covenants with the complications that comes with that. But our traditional covenants here in New Zealand tend to be natural areas on farmland, so only a relatively small percentage. And about a third of our covenants are on what we call rural lifestyle blocks. These are properties, either bush or coastal blocks, with or without holiday homes or permanent homes. Next slide. Now, this is where I have to talk about some of the more boring but important bits about covenants, the current practice in terms of how our covenants are providing protection. So like Australia, all our covenants in New Zealand are granted under specialist protection legislation. In the case of QE2, it has its own Act of Parliament. In the case of our government covenants, that's under our Conservation Act. Like covenants in Australia, they transfer agreed property rights from the landowner to either QE2 or the government. All our covenants are defined spatially, with the one exception where the covenant is the whole title, because that's already defined. They're all registered and available and searchable online, and they are all enforceable under contract civil law in New Zealand. And one of the things that were found recently in terms of our covenants are, because of some court action, they are indefeasible, so they can't be overturned. Next slide. Now, as a matter of practice, QE2 has adopted the stance that we want our lands protected forever. So pretty much all our covenants are protected forever. We have only a very small number that are term limited covenants. They're usually 25 years, and they were established for cultural purposes on Maori land. But with that one exception, our covenants, they're there long term. They all have a defined purpose and objective, and that's very careful, that's very important in relation to one of the legal tests that I'm going to talk about later. They all commit current and all future owners to protect natural or cultural values. And this is probably one difference from my colleagues' covenants in Australia. Ours are immune from ministerial interference. So the only way a covenant can be uplifted in New Zealand is by a whole Act of Parliament and new legislation. They can't just be changed at a whim by a minister. Next slide. Now, my previous slide, that focused on how they're offering protection, but I also want to talk about the provision for flexibility, because I think that's been one of the secret sources of our success in New Zealand. Each of our covenants, each of those almost 5,000 covenants, was tailored to the individual circumstances of the landowner. So that's where we were matching the QE2's aspirations with what the landowner was trying to achieve by protecting their land. So in terms of our covenant structure, the legal agreement, there is a set of standardized, non-negotiable conditions, but all covenants pretty much have bespoke, specialized conditions recognizing individual situations, aspects, and also future aspirations of that landowner. Perhaps if they want to establish ecotourism in the future, or put in a track, or put in a holiday home, that can be set up front. So at the establishment of the covenant, there is some flexibility. Once it's set, the covenant prevents most uses of developments that would be at odds with the purpose and objective, but would allow some uses and future developments deemed appropriate that would work with that covenant and what it's trying to achieve. Next slide. So my previous slide talked about what we did up front, but obviously with the challenge of time, changing circumstances, new owners, climate change, there is the need for some flexibility. So right from the start, QE2 covenants have had an ability for a variation to the agreement. Now that variation has to be by agreement with the landowner and the trust, and we have a strict legal test which is a safeguard so that the variation doesn't undermine the original purpose of protection. So it's a two-part legal test. The first part is any variation allowing a new use or a new development cannot be contrary to the original purpose and objective of the covenant. We've also got another safety valve, which is there has to be the unanimous agreement of our QE2 board of governors to that change. So it just needs one of them to say that's a really bad change that's going to compromise the covenant and the variation won't be allowed. So it gives the balance of the provision for variation, but with a protected landscape. Now, in the case, I got some numbers recently from QE2. I needed to be updated since I left there last year. There's been a steady stream of variations over the years. They average around 36 variations per year processed by the QE2 National Trust. Next slide. Now, given that QE2 has under 5,000 covenants, there's a huge monitoring challenge that comes with that. The policy at QE2 has been trying to monitor covenants every 2 years. And last year, QE2 monitored just under 2,000 covenants. That's 43% of the total. They were monitored for a number of things. They were monitored for environmental conditions, but also for legal compliance with the covenant's provisions. That's a big task. It takes a lot of QE2 time, and it's had to get really smart at doing that by requiring smart tools, and we need great people doing that monitoring who can work with landowners. And of course, when you monitor, you find problems. Of those monitored, about 6% were found to have legal compliance issues that were requiring attention by the landowner, and that was triggering follow-up by the QE2 National Trust. Now, 6% doesn't sound a lot, but those problems can be significant. Now, the approach that QE2 takes to compliance is pretty much most of them we try to deal with by encouragement, persuasion, support, and information provision. You want to only reserve the stick when you really need to. Most of the time you're wanting to maintain the relationship with the landowner because they are the steward of that land. So we've got to work hard at trying to get them on board as opposed to forcing them on board. Next slide. Now, because of the number of covenants we have, change of ownership of a covenant becomes a challenge. And our experience here in New Zealand is the greatest risk of significant non-compliance in a covenant arises after a change of ownership. And that's a growing issue for QE2. So with almost 5,000 covenants approved and registered, that risk is growing over time. About 8% are changing ownership every year. So last year, there were 370 QE2 covenants that changed ownership. Now, one of the things that the QE2 National Trust did about 5 years ago was it implemented regular data matching with our government land registry to early identify a change of ownership so that we can get on top of those challenges as quickly as we can. That allows a proactive response by triggering a new owner information package and engagement process with the QE2 National Trust. Next slide. Unfortunately, engagement doesn't work with every new landowner. And over the last 5 or 6 years, the QE2 has had to resort to court enforcement as a last resort. Now that's related to, in one case it was to stop further damage and to seek restoration in the case of several covenants owned by a dairy farmer who wanted to clear the covenants to include it in his dairy pasture. We also needed to protect several other covenants from major commercial developments, one involving a housing development in the Coromandel and another one where a major quarry was wanting to expand its footprint and take over a big chunk of a protected hillside. Now, those court cases, we've been to the High Court 5 times, the Court of Appeal twice, and we've even been to the New Zealand Supreme Court, all to protect covenants and all from new owners. I'm pleased to report to date of those 8 court cases, we're 8 for 8 won by the QE2 National Trust, although one case is subject to a further appeal. The quarry company hasn't given up yet. It's still trying to fight and has gone to appeal. The experience here is that while expensive court cases have, in our case, established excellent case law, it's greatly enhanced our reputation for providing robust protection, and hopefully it will discourage similar landowners' action in future. And the other thing we got was huge support from most of our covenant owners who were wanting their land protected. They were very pleased that we were standing up in court. Next slide. So finally, I just want to touch on some next generation covenants. One of the benefits that we have under our legislation is that it provides significant scope to the trust in regards its covenant design, including what open space values can be protected, how and for how long. Those are a matter of our policy and our funding. So we aren't as prescribed as, the covenants have to be, forever or 20 years. They can be whatever length we deem appropriate. So this allows us to tailor the circumstances and agreements to individual circumstances. In recent years, QE2 has explored with the New Zealand government the possibility of some new types of covenants. One that we did adopt was as part of the Queen's Commonwealth Canopy Program. That was an international Commonwealth-wide initiative protecting forests in lots of Commonwealth countries, and QE2 delivered that for New Zealand. We've also looked at it in relation to the sustainable management of planted forests, where there was limited harvesting. Now, this is related to new forestry as opposed to old growth native forests in New Zealand. In a similar vein, we have explored as part of our Billion Trees Climate Change program, early stage native restoration projects using covenants. Now, the concept there was using a term-bound covenant to allow proof of concept that the forest was successful before considering a longer term covenant. We've also considered it for green infrastructure. And we have been trying to launch a revolving land use protection fund in New Zealand. Unlike Australia, we don't have that in our arsenal for protection. It will be something that we'd like to do here. I think further developments here, of course, will depend on future strategy of the QE2 National Trust or other agencies, and also funding discussions with the New Zealand government. Thanks a lot. Last slide.
Thanks very much, Mike. That was fantastic. We got to understand some of the challenges that emerge in trying to run a covenanting program and the ins and outs of that. We've got a couple of questions here for you before we move on to Jessica. So one of the questions is that in addition to conservation covenants, New Zealand is known for using the common law to establish rights of nature. And I think that that's been in 3 particular circumstances, excuse my pronunciation, but the Te Urewera National Park, the Wanganui River and Mount Taranaki. Just wondering, the person is wondering what your views are as to the effectiveness of that legal strategy for protecting conservation areas, and whether there have been any judicial cases in New Zealand testing this theory.
It's a really unique approach that New Zealand has led the world in relation to giving personhood to these natural features. There's a very strong cultural context to it as well. It was pushed by the local Maori people for each of those areas who had the special connection to the rivers, the lakes and the mountains that have been protected in this way. I think it would be fair to say it's still early days in terms of how legally robust. I'm not aware of any court cases or an enforcement that has been adopted yet. That may well be the case. but I'm just not familiar enough yet. The people to talk to would be our Department of Conservation, because they have maintained the link and relationship in relation to those natural features. It hasn't been a matter that the QE2 National Trust has been directly involved in.
Okay, thanks, Mike. I think the other thing that you talked about was some mid-term agreements, 25 years. And one of the participants is wondering whether the covenants are limited in duration or perpetual. And I think you said some of them are 25 years. What do you see to be the benefits of the mid-term agreements as opposed to the permanent agreements, and vice versa?
I think the answer is depending on the focus of why it's 25 years. In the case of the 25-year agreements that the QE2 National Trust did, it was because of a cultural context. They were in relation to Maori land. If they had been more than 25 years, that would have caused some problems in terms of the multiple ownership structure of that Maori land. It would have required huge percentage of those Maori owners to agree to it. The cultural context is that's one generation of protection, and then it's for the next generation to decide whether they want to continue that protection. The concept of 25 years, it's 25 years renewable. At 25 years, it allows the opportunity to consider whether there should be the next generation's 25 years protection. All the indications so far is those covenants that we have and the kawanata that Ngā Whenua Rahuri has, which also is largely 25-year covenants on Maori land, that they will roll over when they come up for review. The other reason why you might do 25 years is, or even a shorter term, is where you're doing early stage regeneration protection where there's no guarantee that the regeneration will work. So that allows protection until you reach a milestone that says, yes, it started as pasture, it's now a forest, and it's self-sustaining, it's worthy of permanent protection. So that would be another reason to use a term-based protection.
Great, thanks, Mike. We now might move on to our last panelist, Jessica. And of course, there are literally thousands of conservation easements used in many, many different ways in the US. So it will be really good to hear from Jessica about what the benefits and challenges are in the US and what this now means for the future of conservation easements. Over to you, Jessica.
Okay, great. Thank you. I want to thank you for inviting me to be part of this panel. It's been just fascinating. So thanks to both the ILCN and the ELCN, and it's been really interesting to follow up upon the Australian and the New Zealand questions here. And as Vic noted, the US model and the US use of these tools has been a little bit longer than the other countries, and we have, you know, somewhere under, we don't have good data, so we have somewhere around 50 million acres probably protected by conservation easements. And in contrast to the other countries that we've heard discussed today, we have a real large number of organizations as opposed to kind of the individual being dominated by a few large players. We have, you know, over 1,500 land trusts operating in the United States. So I want to go beyond some of the basics of conservation easements, although they would be fun to discuss in the context of how they differ from New Zealand and Australia, to instead just highlight a couple of big concerns. But before I go into my three big concerns, I want to talk about some background institutional factors. So next slide, please. All right, so just really quickly, one of the things that I see and hear continuously are people who are looking to the US model for thinking about private land protection in their own countries. We even saw it on one of the first slides from Australia, is looking to the US for our agricultural conservation easements or things like that. And in my conversations with people from all over the world, I hear that often said. And I think one of the things we need to stop and think about first is the institutional factors or the enabling factors that gave rise to the US conservation movement, and think about how that might differ from what we see in other countries. countries, and also think about, as that differs over time, what that says about the robustness of the US model here in the United States. And I'm just going to, my research team has a lot of work on this. I'm just going to present a couple ideas, and there's more that we could talk about. But I want to start with just by emphasizing our real strong private property rights culture within the United States, really a culture that sees the individual landowner as really being the dominant force in being able to make decisions about what happens on the land. And we can contrast that very easily to many other countries where there is less resistant to the government coming in and making rules about what people can and cannot do about management of their land. And so that private property rights structure gives rise to a pattern where there are individual deals where the landowner has a lot of power in those deals. And we can combine that with an anti-regulatory effort within the United States that we've seen at two key periods. One is in the Reagan era of the 1980s, when we saw the birth of conservation easements and the birth of the land trust movement. During that era of when the regulations of the federal government in particular, but also state and local governments are withdrawing, we see a gap where private environmental governance can step in. We see that now again with the Trump administration. So that can be frustrating, or it could be seen as an opportunity for private environmental governance to kind of step into the fold. But we have to combine those kind of structures with frankly, a pattern of charitable and community organizations in the United States that's longstanding. We can go back to the writings of de Tocqueville to see them talking about all of the community organizations in the United States and our habit of charitable giving to nonprofits. That has allowed all these land trusts to flourish in a way that we see differently in other countries where maybe there was a lot of government support in at least helping national trusts to get started in some of the other countries we might look at. You also have to have wealth, frankly, to have kind of that tradition and to have that force behind charitable giving to be so such a driver. But none of this is possible without statutory changes. So in the same way we hear about the statutory changes in the laws of parliament that happened in Australia and New Zealand, we had to have similar structures in the United States, but with a pretty big difference, which is that ours are 50 different laws in 50 different states. We have no national laws other than our tax code, which I'll get to in a minute. So we have here a combination of common law, judge-made law evolving over time and based on precedents and kind of traditional ideas of contract and property, combined with some state enabling acts and a real unsettled way of trying to figure out how they're going to work together, as I'll talk about more in 2 more slides. But before I get there, I wanted to mention 2 other areas of law. Of course, we can't talk about conservation easements and private land protection in the United States without mentioning the taxes. The taxes and the tax incentives for donating conservation easements in the United States is undeniably a driving force of this movement and what led to the real development, even though not all conservation easements are donated or come associated with that, that process. That law is really served as a catalyst to kind of get a lot of the private land conservation movement going. And that means when we're looking at conservation easements, we have to make sure that they're complying with this state body of law that tells you just the mechanics of how they work, but also this federal body of law that kind of talks to you about whether or not they're going to be qualifying for donation, which are 2 separate questions. Those federal laws don't tell you about the enforceability, they just tell you about the deductibility. But because of the prevalence of them, we see most conservation easements invoking and looking to that federal tax law, even when they're not conservation easements associated with donations. But a third category that I want us to really think about, because it's not discussed quite enough, is the role of environmental permitting programs and land use permissions. Within the United States, and I'm sure this is true in your countries as well, when you want to develop something, you have to go get a lot of permits and permissions from the government, and that can happen at local, state, and federal level here, the different types of permits you need to get. When you apply for those permits, you usually have to exchange things. You have to make payments. You have to protect the water that you're using. You have to help put in new streetlights if you need it. So we have increasingly seen conservation easements as part of that permitting process. So in exchange for your housing development, you have to protect a huge number of acres. And I just want to suggest to you how different that is than the model of that we've just seen from Australia and New Zealand, where that is the driving force. where what you're really trying to do is develop, and the conservation easement is a tool to help facilitate the development, we might get very different attitudes and structures about how they're going to look and be enforced over time. All right, so next slide. So those kind of foundational factors are important for us to think about because they kind of suggest whether how those factors change will affect how this movement goes forward. But what I want to take a moment to do is take on just three really big questions about kind of conundrums we're facing with conservation easements here in the United States. And so these are the three categories of complicated questions I'm going to go into in just a little bit of detail. The first is looking at the conservation easements themselves and how the uses of those the land are expanding. And what I mean by that is what types of land are being protected, what types of things. So the movement into working landscapes, cultural landscapes, things we've heard from the other countries as well. And also the purposes for which we are putting to those conservation easements. Alongside that, I want to tackle like a really tricky question here, which is what are judges doing with these? We don't have the clarity that I've seen mentioned from New Zealand, at least, of how to interpret and deal with conservation easements. And so I'm going to talk a little bit about that and then leave us with kind of the biggest, hardest question of all, which is how do we kind of balance this flexibility and permanence within our US legal structure? So let's go to the next slide and start with the purposes and uses. All right, so this is just a couple pictures to get us started in thinking about this, and these are kind of from a research project we did a few years ago where we looked at over 360 conservation easements from 6 different states, and as we approached the land trust and the holder, we asked for a span of years of their documents. So we got their oldest and their newest ones in this database. And this is a really rough cut. If you want some more details, you can look at the fuller article. But this is just asking a simple question of, in the light blue, looking at all those conservation easements from before the year 2000, how do they look compared to the darker blue after the year 2000? And we see some significant changes. First of all, the conservation easements got more pages, they got more details, they got more provisions in them, and here's some real specific ones. If we look on the left, we see they got more uses. There was more things you could do on the land. There was more allowance of development, more allowance of harvest, more allowance of forestry and of agriculture. Our data showed not maybe slightly surprising patterns on rangeland uses, but in general, the pattern overall was that you could do more things on this land, suggesting that early conservation easements were kind of very rigid, protect this land, don't do anything on it. And over time, we started to kind of allow conservation deals to be more complicated and protect things that did more. Which brings me to the second half of the slide here, which is just the number of uses. So this isn't even tracking, you could look in the paper for more, tracking the types of uses, what the uses are, but just how many are there. So as with New Zealand, we also have to have a stated purpose for our conservation easement. And it's very rare that a conservation easement has just one purpose. You see, even in our early days, we only had about 6 conservation easements that had one purpose, right? So generally, they're doing multiple things. And let's take an easy example. We want to protect endangered species habitat, but we also want to provide recreation for people. So over time, we're increasing the number of things. Maybe we are adding cultural heritage, and now we're adding watershed protection. And we see that a big increase in the number of purposes. And that can lead to 2 kind of things just to start with. One, well, what happens when there's a conflict with these 2 purposes? We can see pretty easily that we could get a conflict between endangered species protection and access. The purposes do not generally highlight any hierarchy of purposes or a main purpose, and nor do our statutes or interpretive rules from the courts tell us how we should prioritize what to do with conflicting purposes when they come in, when they came before them. We don't know what to do with it, and the more purposes we have, the more opportunities for conflicts like that. Also, though, we can see that there might be a resiliency added by multiple purposes. What if we have our 2 purposes of endangered species and recreation, and the species has gone extinct? Well, we still have our protection on the land because the recreation purpose may be there. So we also see organizations adding purposes for the hope that it makes their conservation easements more robust over time. So next slide. All right, so the last, the broader questions here come under this idea that we really don't know what to do with the conservation easements once they get to the courts, or the courts are really troubled by it and they're working to figure it out. But they have some fundamental questions that are unanswered by the statutes themselves, which are just things like who can enforce a conservation easement? The parties to the agreement, but what about the government? What about taxpayers? What about neighbors? Who could change it? Who could the parties agree on a change themselves? Does it have to go through a court process? We now had to figure that out in all 50 states and with little guidance. And in particular, just this last one, right? What is a conservation easement? Is it a servitude and then we enforce it by property law? Is it a contract and we use contract interpretation to bring it on? I was fascinated to hear New Zealand just says they're contracts. We have nothing like that in the United States. So courts, judges are developing their own approach to what this means. Nancy McLaughlin and others suggest we should draw upon charitable trust law and use that. Or maybe there's a fourth category of some kind of environmental principles that we can invoke that we should use. But we don't have an answer on that we don't. So we have 50 different states grappling with how to pursue that, and then the IRS giving us its own interpretation as well. So let's go to my last slide and leave you with the hardest question of them all, which is flexibility versus permanence. We're dealing with pretty much a rigid perpetual tool, and we're trying to figure out how that can map onto a world that is not rigid or perpetual. What do we do about that? So this kind of colorful Venn diagram shows you ideas of what we could do about that within a conservation easement document itself. And so this was, again, an examination we did of a bunch of conservation easements and saw what they were doing. Some of them put amendment terms in there. We don't know if the courts are going to like that. Some of them say management plans. We won't define it here. We'll create a separate document where we have all the details, and that way we can keep changing that document. Again, unclear what we think about those. Or perhaps a certification. If you have to be certified organic, maybe then you, as the organic rules change, you have to change. So we see kind of some opportunities and ideas that parties are engaging in to try and add flexibility into their documents. All of those internal, we don't have an external kind of clear rule of how we would deal with change. I mean, like a legal rule or an interpretation. So we are still struggling with this, and I'm eager to learn what's happening in other countries and think about how we can be more creative about this. So I leave with you with those like huge questions and look forward to further discussion.
Thank you very much, Jessica. And we might take a couple of questions for Jessica before we open it up to the panel as a whole. And can I again just remind people that if you've got any questions, can you use the Q&A function button rather than the chat button? That would be really great. So Jessica, just touching on what you just finished with there, which are, there are a range of options for dealing with the opportunities and the challenges around flexibility, and you listed a couple of them. In your view, what do you think are the most logical or the strongest or the clearest of those options at this point? If you could just take it one step further for us.
Oh, can I say it depends what state you're in? It depends on if you have a donated conservation easement or a purchased conservation easement. Right, the donated conservation easements have to be perpetual, and the IRS has taken a kind of narrow view on that and makes it harder to put kind of mechanisms for change within the agreement. There's things about management plans that are very attractive, right? Because we could say you have to have a management plan that helps you figure out what you should do to get the most conservation or most ecosystem services out of this land. But I worry about those because one of the things we have seen is sometimes when parties have trouble negotiating, when they can't reach a resolution on what they want to do on the land, they punt it to the management plan. They say, we'll just put that in the management plan. And it's become, for some parties, a way of avoiding hard questions. So I don't have a good solution. It just shows you how case by case they all have to be.
Yeah, okay. Well, I consider it's very complicated in the US because of all of the different states and, as you say, the expanding uses for conservation easements. So,
Vic, this is Laura. Can I just chime in with a quick question that might involve both Mike and Jessica, which is Mike, how do you think in New Zealand the courts, well, I'll say it this way, the courts came out the right way, right, in terms of the interpretation of those cases you were describing. And I think, Jessica, it's fair to say that a lot of courts in the US don't have the expertise to kind of actually understand. In other words, they don't deal with conservation easement enforcement very often and the questions that go with it. So Mike, how can you explain those outcomes with regard to your court system? Is there anything that anybody did to make sure that courts were able to understand the issues at hand?
Thanks for the question, Laura. I think there's a couple of aspects in the New Zealand situation. One of them was the people who wrote the QE2 National Act were really smart. We had one of the very first chairs of the QE2 National Trust was a former High Court or appeal court judge, which in that day was the highest appeal court. So he's a very smart legal mind. So the legislation has a very strong foundation. We also, because of our monitoring and information and, you know, the track record of what's been happening on land, we were it was very easy for QE2 to demonstrate where damage had occurred and to document that and to explain why that was an issue in terms of the contract. In the case of the other cases where damage hadn't occurred, but the landowners wanted to develop the land and would have caused significant damage, we were both able to point to the original agreement and the motivations of the original landowner, because the covenant has to you know, secure the original landowner's motivations. So that was very important in terms of demonstrating what the contract was trying to achieve, its purpose, and why the development was going to be at odds with that development. So we're very happy to date, you know. And of course, the other thing that has developed through this process is we now have excellent case law in New Zealand, which really helps us with any further issues of this nature. New Zealand covenants were found to be indefeasible. So even if there were errors in the drafting of the original covenant, as soon as it's changed hands, that doesn't matter anymore. The intent of the covenant is what matters, and if you can clearly see the intent of the covenant and the activity is at odds with that intent, then you're not allowed to do it. Full stop.
And I think, Laura, you were also directing that question to Jessica.
Yeah, I'd be interested in her perspective on that.
Just jealousy, I guess. We have some kind of fundamental differences here between the two. That it's so interesting. You know, we think of these, oh, there's common law, same ideas, but I think there's first of all a clear acknowledgement of what types of principles they're going to use for interpreting. If you have something that says we're going to use contract law principles to interpret these documents, that gives courts a little bit more guidance. You have it being done at a national level, and instead of this kind of piecemeal 50-state approach. I also wouldn't underestimate the power of the funder here, right? The fact that ours are often associated with donations and IRS funding kind of complicates courts' interpretive rules and how they're going to handle them. Both a feeling that the IRS's position against amendment should be really a strong one, and also just kind of perhaps a feeling by members of the public that because these were donations, they have a kind of a different governance structure or feeling to them. We have nothing like the indefeasible statement. I shouldn't say we have nothing like that. We do have, I think that is similar to kind of some of the ideas that we should consider them to be charitable trusts, and that way we would not dissolve them. We would kind of try and change them and to modify them to get them to be accommodating of what the basic general principles are associated with maybe an idea of a perpetuity that's a struggle.
Thanks, Jessica. So what I'm going to do now is we've got a number of questions coming in, so we're going to open this up to all panelists. questions for all of you for the next 15 to 20 minutes, or until I'm given the sign that it's time to wind everything up. Having said that, I am going to start with a question back to Jessica. Someone, while we're on this topic, someone is asking, do you see a general trend in court thinking toward enforcement of permanence or towards allowing greater flexibility of interpretation?
Oh, so, you know, that's a great question, and one that we're working on here. So I have deployed my law students, and we are gathering and coding all of the cases that mention conservation easements and that interpret them. And we're trying to figure out what types of interpretive rules courts are using, what are they looking to, or what seem to be kind of the developed mechanisms. So far, we haven't quite yet figured out a strong pattern of other than following precedent once we get one, but we don't have kind of, oh, these are like contracts and we'll do this. I do think that courts do not want to remove them, so the trend is towards permanence, but also in an inflexible way. They are also finding not really wanting to be allow them to change or be adapted. So even, for example, moving a building envelope, you know, you had a conservation easement that said you could build on the left side of your plot, now you want to build on the right side for whatever reasons. Even a change like that, which we wouldn't think of as maybe changing a conservation outcome, is really being questioned by the IRS and by courts. So I think there is really a struggle of allowing permanence, but prohibiting flexibility that is going to, I think, run us into trouble.
And where do you think things are likely to be in 10 years' time on this score?
Well, I think we'll get more court cases. And so as we develop more precedent, maybe we'll get some of the certainty that they're seeing in New Zealand. With it sounds like Mike feels very good about which direction a court is going to go, whereas each opinion I read, I'm like uncertain what they're going to say. So I think as we see the court cases develop, that we'll get a little bit better view of where we're going. And we're also seeing more kind of movement from Congress and the IRS, at least on the deductibility question, that will also influence where they go.
Okay, great.
Could I just comment on that? One of the challenges in every court case we went into, we didn't have certainty. And in every case, there was a discussion, should we proceed? Is this more important? Or should we try and do a deal to try and get a out-of-court settlement? So you have to weigh that every time, because you know, there's always a risk that there'll be some minor legal provision that we hadn't recognised, that a higher court decides that changes the lower court's decision. And in the case of the Act or the covenant that went right through to the Supreme Court, so went through the High Court, the Court of Appeal, and the Supreme Court, they all found for protection of the covenant, but they all found for slightly different reasons. So the case law did evolve through all three court cases. You know, the High Court here is a couple of judges, the Appeal Court is 3 judges, the Supreme Court is 5 judges. It's the highest court in New Zealand, and each of them had a slightly different take. Now the Supreme Court has established what is the law and what is the case law. So that is the law here. We were nervous as hell in every case, and we were just very pleased that we won.
It sounds like you have just described legal systems, Mike. Everybody has a slightly different take on something, but very fortunately for New Zealand, it's coalesced into great clarity for you. Now, moving just for a moment from a focus on the legal matters to finance matters. A question for you, James. What is the return, thinking about the big project that you described, what is the return for impact investors and the period of return, and a bit more insight into how this all works? What's the deal here?
Sure, thanks, Vic. I'm actually not sure we're at liberty to talk about the return. Certainly, Tiverton Agriculture had a range of investors they've dealt with previously. certainly for some of our past impact investing deals, when we were dealing with a process called the Murray-Darling Basin Balanced Water Fund, those returns, we talked about predicted returns and what they were. In this particular deal, I'm not sure we're necessarily at liberty to say. Having said that, the returns are fairly attractive in terms of what's being promised to investors. There's certain mechanisms between the Nature Conservancy and Tiverton Agriculture to guarantee those returns. So we've just got to, it's a combination of what actually happens on the property from either grazing, biodiversity stewardship payments, or other forms of conservation that might return a profit. But those deals and mechanisms are fairly internal at this stage, so I don't think we're quite at liberty to talk about how that works.
Yeah, no, okay. Well, thanks very much, James. So thinking again, there's a question for Mike and James, and this is again is looking to the future. What is the approach to, for example, solar installations that are proposed for open lands deemed to be of high conservation value? So that's a specific example. And are there permitting incentives to site such installations? Do you know anything about that, Mike and or James, in your respective contexts?
I could just describe how we would deal with a request to site solar panels in open land. So if there's a covenant that's protecting the whole of the farm, and if the covenant is if it's biodiversity and landscape protection, then we would assess whether that solar panel was going to be detrimental in terms of the visual landscape, and whether it would be having any impacts in terms of both its operation and its construction in relation to the natural values. If that was deemed to be a significant risk, then we wouldn't allow a variation to allow it. When I say we, this is the QE2 National Trust. If it was deemed to be de minimis, minor impact, and the overall benefit is such that for the wider environment, then the trust may consider it. But it would be a two-stage test. We would have to assess it if it wasn't already allowed for in the contract, the covenant agreement, and we would have to assess its effects. So it puts the trust in the similar position to a regulator considering environmental impacts, but the test for us is the covenant agreement itself.
And in my slide, I was talking about the potential for solar at Gaining near Mikaira. These are being considered on formally cleared areas. So I think, typically in Australia, large-scale solar and covenants with natural vegetation probably don't go hand in hand, it's fair to say. I think where there are, as Mike's indicated, there are past areas of sort of agricultural areas or areas of less conservation value, they might be considered. I think a scale issue is also important here. If we're talking about a large commercial farm, it's quite different to a small plant that might be servicing a manager's house, for instance. So I think it's all in context, but typically if you're looking at vegetation damage from solar, they don't necessarily go well with covenants.
Thanks, James.
Just one more thing to say about that. In the case of New Zealand, if that was part of an original proposal, we would consider it, but because generally when we're protecting farms, we're not trying to protect the whole farm. We're generally trying to just protect the natural areas in a farm. In that sort of situation, we would probably suggest don't include that in the covenant, have it outside, and therefore it doesn't affect what you're trying to do.
Okay, thank you very much. Now we've got a question here about the concept of or the practice of purchased conservation easements. This is a trend of significance in the US, where a significant amount of acreage is subject to conservation easements in situations where state, local or federal agencies, or a combination of them, has paid for the easement. So the question is for the non-US panelists, i.e. James and Mike. Could you speak about the extent, or for that matter, I suppose, the potential of purchased conservation easements in New Zealand and Australia?
I'm not quite understanding the question, Vic. So,
okay, the question is where the government is prepared to put up the money to pay for the totality of the conservation easement. In the US, it will be more than just a small incentive for a landowner to do the right thing, but where they are effectively acquiring all the rights of that land and putting a conservation covenant on it.
So the trend in New Zealand generally in that sort of situation is for that land to then transfer to the public conservation estate. They don't tend to, we've been promoting the concept of government working with the QE2 National Trust to buy land, to covenant and on sell it. That's very much the model, Vic, that operates in Australia. But traditionally in New Zealand, that's very light. In fact, one of the differences in New Zealand to virtually anywhere else is we've got one of the lightest regimes in terms of encouragement of landowners. When the QE2 National Trust covenants with the landowner, they might contribute to the costs of the fence, usually about half the cost. The landowner meets the other half of the cost because most of our areas we need to fence out from grazing stock because of the nature of New Zealand's biodiversity. We pay for the legal cost to do the covenant, but we don't give subsidies. There's very little direct financial incentive. Most of our landowners are doing covenants because they think it's the right thing to do. They're not doing it because of financial incentives. And one of the nice things about that is we don't have the complexity of the IRS telling us how to enforce a covenant. So when we're considering covenant enforcement, it's based on what we consider to be the environmental and biodiversity values, not a financial agreement in terms of tax rebates. So in the case of a landowner who had permission to do a property platform on one part of the covenant, but has decided that that's the wrong place to put it, it wants to put it somewhere else, we consider that on environmental grounds. We don't consider that a breach of the covenant. And if it's sensible, we will allow a variation to do it.
Yeah, and I remember you explaining that to me on other occasions, Mike, that really they are very much philanthropically based in New Zealand. So I might flip to James here. I think there is a bit of a theme here, which is what is the role of government in, if you like, using conservation easements themselves, either acquiring them for full value or using them to avoid a private landowner having a covenant on them.
It's a good, yeah.
Yeah.
So Vic, in Australia, the regimes vary quite dramatically between states. Some states will offer some generous incentives, others will offer nothing. And I think it's only been probably in a rare case in Tasmania under a very dedicated scheme whereby there was an attempt to get more particularly underrepresented forest types into the privately protected area state where large amounts were paid, almost up to full value of the property. But that's a very rare example. We'd actually never use the term buying a covenant in Australia. I think that term is kind of a strange term for us to think about. Certainly incentives are offered, but really they're out there, they're on the table for people to apply for. There's I'd say very little targeting with large amounts of money at any one property at any one time. They're often parts of a tender, a bidding process that landowners that are interested apply, as opposed to large targeting with large amounts of money for any one property. So it's quite a different regime and prioritisation process in Australia.
Great, thanks you very much, James. I can see that we're coming up towards the end of our time here, and I might finish with just one final question for Jessica, which is a real wrap-up question, Jessica, and that is, what is the challenge of conservation easements in the US right now?
I can only pick one. Well, I think our challenge is actually to how to deploy them in a way that gives us the most conservation benefit. I'm very envious of the large organizations that you guys have in your country, that countries that can really kind of coordinate and be strategic in a lot of these. When we do have, of course, the Nature Conservancy, but we also have all these smaller organizations out there, and we have plus government agencies, and it tends to be an ad hoc process. I would love to see conservation easements deployed more strategically to help kind of improve the value of already other existing protected areas, and how can we use it kind of to kind of get bigger bang for our conservation buck.
Thanks, Jessica. Now, I've probably got 1 minute to summarize all of this great discussion from our panelists before I hand back to Laura. So what I've heard really is that privately protected areas are very important and are growing to conservation in all of the jurisdictions we've heard of today. They're critical. And that the use of easements and/or covenants is expanding and is developing. Flexibility is becoming typical, and it is becoming very important. And that our protection instruments have a critical role to play in the conservation of our lands in all of these countries. And of course that the law is never endingly interesting. Jessica has raised for us all of these amazing legal issues, which when I listen to it, make me think that our questions are going to go on forever. But the really good thing is that they're not holding any of these jurisdictions back from using these private law instruments to advance conservation, which is fantastic. So thank you very much. And Laura, I think with a minute to go, I will pass back to you.
Great. Thank you, Vic. And thanks to James, Mike, and Jessica as well. Those were great presentations. I can see that we could keep going with more questions and more debate because some of these such interesting issues have been raised. But we're going to stop now. And again, thanks to all of you for taking the time to listen in on this webinar. And please note that the next webinar in our series is going to be on May 6th, which is next Wednesday. And it is, as you can see, peer learning and collaborative leadership in large landscapes. So you can go to the ILCN website and register for our next webinar. And again, thanks so much to our great moderator, Vic, and to our panelists for those really interesting and thought-provoking presentations. And so I think we can say that we are adjourned. Thanks again, everyone, and be safe.
Yeah, stay safe.
Bye.